Good afternoon, everybody. Welcome to today's webinar presented by the Mid-Atlantic Planning Collaboration. We're thrilled to have you today for this presentation. I would like to share a couple of announcements and general reminders before we get started. Don't forget to register for next month's Your Hour with APA Virginia webinar, which will be presented on December 13th from 12 to 1 p.m. This is a week early due to the holidays. Please mark your calendars to note this change. All information about our upcoming webinars can be found online at virginia.planning.org, as well as links to registration. This recorded webinar can be found on the Mid-Atlantic Collaboration page YouTube site, which is also linked on our website. We encourage you to submit questions throughout the presentation in the Q&A box at the bottom of your screen. When we move to the Q&A portion of the presentation, we will take your questions in the order that they were submitted. If you would like to ask a question live to our presenters during the Q&A session, please use the raise your hand feature at the bottom of your screen, and I will let you unmute yourself to speak directly with our presenters. With that, I will now introduce our session and our two presenters. Today's webinar is regulating short-term rentals, and this session seeks to enable the planner to be able to identify community concerns arising from short-term rentals, evaluate various regulatory alternatives to address the concerns, and along with the local government attorney, develop a regulatory approach to address a particular community's concerns with short-term rentals. The speakers will discuss specific concerns and ordinances and will review and apply case law from across the country. We're joined today by Jesse Richardson. He is a professor of law at West Virginia University College of Law and the lead land use attorney at the Land Use and Sustainable Development Law Clinic. He previously taught in the Urban Affairs and Planning program at Virginia Tech. We are also joined by Christy Burnside DeMuth. She is the land use planner at the Land Use and Sustainable Development Law Clinic. Christy received her Bachelor of Science in Environmental Resources Management from Penn State in 2003 and a Master of Science in Geography from the Indiana University of Pennsylvania in 2005. Before joining the Land Use Clinic, she worked in local government and the private sector as a land use planner. Christy joined the Land Use Clinic in 2012 and has worked on the development of several comprehensive plans, zoning ordinances, and subdivision and land development ordinance in communities throughout West Virginia. Christy also educates local government officials by facilitating educational sessions on the importance of planning. Christy is also a member of her Township Planning Commission in Pennsylvania. She spearheaded and participated in the 2018 Comprehensive Plan and 2020 zoning ordinance updates as a Planning Commission member. I will now pass this on to our presenters.
Thanks, Taylor, and we really appreciate everybody coming today. I think short-term rentals, if not the hottest issue in land use today, is certainly one of the hottest issues. And at the Land Use Clinic at WVU, we have talked to a lot of local governments, and we've done a lot of research on this issue to try to come up with some reasonable a set of regulations. And in West Virginia, like in some states across the country, the state legislature has stepped in to at least partially preempt what local governments can do in West Virginia. We think that some of the techniques that we're going to talk about today are permissible in West Virginia, but I always have to lead off with what we're going to talk about today is not legal advice. And we urge you all to talk to your local government attorney, your legal counsel, to talk about any particular ordinance language or any particular situation. This presentation today is for educational purposes. I do want to mention the Mid-Atlantic Planning Collaboration that Taylor mentioned as well. It's a joint venture of the Delaware, Maryland, National Capital Area, Virginia, and West Virginia chapters of the APA, along with the Maryland Department of Planning, Maryland Planning Commissioners Association, Rural Planning Caucus of Virginia, and the West Virginia Land Use and Sustainable Development Law Clinic. And we're hoping that Pennsylvania will officially join as a member as well. This collaboration was born out of the pandemic, but it's really grown into something far beyond our wildest dreams. It's been wonderful to work with all the chapters and all the people across the region, and everybody involved has been wonderful. But I want to give special thanks today to the Virginia chapter of the APA for both hosting our webinar today and for sponsoring the CMs. You will get 1.5 law CM credits for today. And we have a great crowd. I looked at the registration list. Some of my former students from Virginia Tech. I wish I could reach through the cyberspace and pick on you and ask you specific questions, but I can't. And some lawyers from West Virginia, so I'll try to be careful about what I say. At this point, I'm going to turn it over to Christy to get us started on, to talk about the clinic and to get us started on the substantive portion of the webinar.
Thank you, Jesse. So the Land Use and Sustainable Development Law Clinic is very unique in the United States. We're one of the very few land use law clinics in the country. We have 5 attorneys on staff and 2 AICP planners, one of which I am. And the clinic was formed in 2012, and from 2012 to 2018, we have helped protect over 15,000 acres of land, facilitated over 500 public meetings, and assisted in the completion of approximately 40 comprehensive plans, zoning ordinances, and subdivision regulations, corridor studies, and source water protection reports. We also partner with private consultants on the legal end of the planning process. And most importantly, we work with 2nd and 3rd year law students to help educate them on the benefits of planning and local government law. So just briefly, I wanted to go over what our presentation is going to entail. So initially, I'm going to speak first on the different types of short-term rentals, the impacts and concerns that many of our communities throughout West Virginia, and I'm sure throughout the country, have on short-term rentals. And then Jesse is going to speak about the regulatory strategies and the recent case law. So, as I work throughout West Virginia with communities and comprehensive plans and zoning ordinances, I would say within the last 5 years, I've heard a lot of concerns about short-term rentals. And so we decided that we really needed to dig deep into this and determine, what the main issues and concerns were and how we could address them for our communities. And there are 4 main types of short-term rentals. The first type is where the owner rents out part of the house or garage and remains in the house. Now, I would say a couple years ago, this was probably more common, but in the last few years, we have seen the owner lives in the house part-time and then rents out part-time. I have one particular community in Southern West Virginia that they have a lot of people in the winter months leave and go to Florida for the winter. And so they like to rent out their house in the winter to, gain a little bit of income, and their house isn't sitting there empty. So that's becoming more and more common because we have a lot of retirees in West Virginia. And then I would say what's becoming more common and is definitely going to become more popular in the next few years is investor owned, where the owner is never at the house. It's simply just a short-term rental. And I would say probably, initially this was done by small business owners, maybe people locally in the community that just wanted to buy a house and rent it out as an investment property. However, I just recently read in the paper that there is a large scale company now that has decided they're going to invest over $1 billion in buying over 5,000 short-term rentals throughout the United States. So I think this is going to become probably, more common and has a whole host of issues along with it. And then lastly is accessory dwelling units. This one is not as common in West Virginia, but I know throughout the United States, it's very common where someone will rent out their garage or maybe even have a separate dwelling unit like in their yard or whatnot for short-term rentals. And this one is very popular because accessory dwelling units tend to be more private, but then the owner is there on the property if there's any issues or concerns. So as you can imagine, there are many concerns that I hear from my communities throughout West Virginia. I think one of the biggest concerns I hear is parking. A lot of our communities in West Virginia are very small, and parking is a concern on a normal day, especially, as families have multiple cars now, 3 or 4 cars. And then when you add in people coming to visit on the weekend, that creates an issue on the streets where there's no parking. And then you have people parking, in the yard. And that just kind of distracts from the residential character of the neighborhood. So I hear a lot of concerns about parking. I think the second biggest complaint I hear is noise. We have very quiet residential communities where on the weekend, in one particular community, there would be, 15, 20 people renting a short-term rental, and they would be up all night. And so that was the concern with the noise and loud partying. And that goes into, this isn't as common, but I have heard from a few communities that criminal behavior is a concern. One particular community we worked with, they found out that short-term rentals were being advertised in their community as kind of party spots, like come here for the weekend, we're having a party. And there was a concern with alcohol and even drugs in those units. And then I think, one of the biggest concerns, and this leads into the parking noise and criminal behavior, is that short-term rentals are changing the residential character of that neighborhood, where you have people that are coming in every few days, you don't know who they are, and it's really just changing the residential character of the neighborhood. And then I think these two pictures are really indicative of what's going on throughout the country. And this is, I think it was in Arizona where it was somebody I knew that was actually staying in a short-term rental. And the neighbor next door had a sign that said homes, not hotels. And then the short-term rental had in their yard, it says, calm down, Karen. And so you really see that dynamic between people that live in the neighborhood on a daily basis, and then those that are, just wish to rent out the home for maybe extra income. So this is a huge concern in communities that do not have a lot of rental properties to begin with, and really struggle with providing an affordable housing. And so when you have homes being bought to be simply short-term rentals, that does impact your rental property inventory. It also can lead to an increase in the cost of housing. It could increase housing in neighborhoods that typically would have been affordable, but now your average American cannot afford to buy a home in this community because short-term rentals have become so popular. And I hear this, I would say, 99.9% of my communities are concerned with these short-term rentals not paying taxes. They might be okay with short-term rental in their community, but they want them to pay their fair share, just like hotels and motels. We've all seen the stories where, rentals have had issues with decks collapsing because they weren't up to code and too many people were on the deck. And, that's a concern, as well as, these short-term rentals, do they have the proper fire alarms and CO2 monitors and ingress and egress, especially if it's, a basement conversion? Are there ways for people to get out if there's a fire and an emergency? And one of the biggest concerns I hear about some of my communities that honestly really might not want to regulate short-term rentals, but they want to have somebody that they can call if there's a problem. In West Virginia, people just want to work out some issues. And so they want to have somebody they can call and say, hey, those people that you rented to over the weekend, they had a party and loud noise and it really disrupted the neighbors. Can you please make sure that doesn't happen again? And a lot of times you have no idea, especially if it's an investor-owned property, who to contact. So that's a concern as well. And then I think, we'd be remiss not to discuss how this is impacting the hotel industry. In some communities where there's no hotels, short-term rentals are filling that void, but in a lot of tourism areas, this definitely is going to impact hotels because a lot of people would prefer to stay in a short-term rental. So what does that do to that industry? And then lastly, and I know Jesse talks about insurance a lot, are people notifying their insurance company that they're renting their short-term rentals out? Now, I talked about the concerns, and there's a lot of concerns, but I will say there are a lot of positive impacts, especially in West Virginia. There's positive economic impacts, especially in West Virginia, where we have some of the greatest scenery, biking, hiking, on the East Coast, honestly, and maybe I'm a little biased, but we have a lot of communities that do not have hotels. I work in a lot of very rural areas that have small towns and cities that have, quad trails and hiking trails and people that want to visit the community, but there is no hotel for them to stay in. So short-term rentals really do help that issue, and it gives communities more economic impacts. That gives them tax dollars. They're going to the restaurants in the community. They're visiting their stores and the retail, and it's increasing their tax revenues. And it also provides diverse accommodation options. Not everybody wants to stay in a hotel. And then something too, and I think this is probably true throughout the United States, you have a lot of times large events, Super Bowl comes to mind, but in West Virginia, maybe a large festival that attracts people from all over the country. And the hotels typically will, raise their price for that. Well, short-term rentals help, stabilize those events, those costs, and make them more affordable, and also provide communities that wouldn't have been able to host large events. If they have some lodging available, they're able to do that. And then lastly, I think this is very important in West Virginia. We have a lot of retired people in West Virginia. This short-term rentals really help increase financial gains for property owners. It gives them a little extra income that they normally would not have.
So we were really prompted, given the advantages and disadvantages that Christy just talked about. In our communities in West Virginia, honestly, I've seen some great comments too that we're trying to do win-win, and that's definitely true. Most communities in West Virginia want short-term rentals, but they're trying to balance some of those negative impacts on the neighbors. And so when the West Virginia legislature passed a statute that limited what local governments can do in West Virginia with respect to short-term rentals, we decided it was time for us to kind of take a deep dive, like Christy said, and figure out how we can approach this while staying within the law. And the first thing we ran into was the definition of family. So, we're back to the basics and back to the Belterre case. And my students better know what I'm talking about. But, and I ran into two Pennsylvania cases that talked about the definition of family. And particularly, I would recommend the slice of life case. In that case, the judge really went into depth about the history of single-family residential zoning, starting with the Euclid case, and really looked at a lot of the treatises and a lot of planning theory, and said that short-term rentals are really antithetical to single-family zoning. And some of the definitions that are being used in Pennsylvania and across the country will include in the definition of family terms like nonprofit, relatively permanent, and stable. And like I said, that slice of life case really goes into detail about how these types of characteristics are intrinsic in a family, and about how, and again, if you read the Belterre case, parking, traffic, trash, overcrowding, noise, water usage, and wastewater. And so one way that you can start to determine where and how short-term rentals should be in your community is to look at your definition of family. And does it include transitory families? And the argument always is, well, we're renting the property on a short-term basis to a family. But the argument on the other side is having a different family in there every week is not really what's intended by single family residential. So look at your definitions. And we're going to talk about some more definitions when I look at the cases, because other courts have looked at terms like dwelling and residential and said that those terms don't necessarily jive with short-term rentals. The second strategy that we have started to use, and I'm going to give a shout out to Ken Sayer. I know you were registered, Ken. I hope you're out there, but I was inspired by your drug house ordinance. And I said, instead of targeting short-term rentals, which the West Virginia Code doesn't allow us to do anyway, let's go old school and put it in the nuisance ordinance. Now, a lot of nuisance ordinances have historically had sections called boarding houses. I don't think we can do that in West Virginia at this point. But as a refresher, a nuisance is where somebody uses their property unreasonably in a way that interferes with another person's enjoyment of their property. And nuisance ordinances typically address junk accumulation, noise, dangerous buildings, unsanitary conditions. And so we take out the boarding house reference and we just address these concerns of parking, noise, litter, and traffic very broadly. So it doesn't target short-term rentals. It could be owner-occupied house that has the same problems, but we define that as a nuisance, and that gives the local government some power, authority to go out and to address it. And I felt vindicated when I started reading some cases, and I'm going to talk about the Zatari case again in a few minutes. But in that case, the court specifically said that the city of Austin had passed an ordinance that looked at trying to limit the number of people who can gather and limiting short-term rentals to adults and things like that. And the court said, why don't you just do a nuisance ordinance? That's a better way to do it. And they struck down the City of Austin ordinance. The third thing that we've done is, and this, we had already done this, but we really kind of refined what we do. We have a definition of bed and breakfast in our zoning ordinance template. And in that definition, we talk about the types of short-term rentals that the community allows. And that usually involves limiting the number of occupants, and it might involve having the owner reside on the premises. Christy, what kind of provisions have you included in some of the zoning ordinances that you've drafted?
Yeah, so one way we have decided to address short-term rentals in the community, as Jesse had mentioned, is through our bed and breakfast use category. And we typically have two different types of bed and breakfast. One is your traditional bed and breakfast that allows a certain number of guests, and that's really up to the community to decide how many guests. but the owner has to reside on the property. And that is your traditional format of a bed and breakfast. The second type of bed and breakfast is that the owner may or may not live on the property, and you can employ X amount of or people visiting in a certain time frame. And some communities don't want to limit how many days that, the maximum, whereas other communities do. And also, the number of guests, some communities are a little more generous in allowing, say 10 people at one time, where other communities are a little more strict, maybe allowing 5.
There are a lot of other regulatory strategies, and we're going to talk about a number of those. One is owner occupied requirements, and I think we've had a couple different ways that we've dealt with that too, Christy. How do you deal with defining what owner occupied means?
So we really leave it up to the community, because there's not a one size fits all approach. Some of my communities want owner occupied to mean a certain amount of days a year the owner needs to be present on the property, because they don't want homes being solely short-term rentals. So for instance, one of my communities that had a lot of retirees that go to south for the winter, they wanted to allow them to be able to rent their homes out as short-term rentals when they're not there. And so I think we, said basically 180 days or whatnot would be considered owner occupied. Some communities really don't care about this requirement. I have some communities that, maybe they have a lot of issues with vacant and dilapidated housing, and they think it would be great if an investor would come in and buy this property up. So it's really just up to the community how they want to define owner occupied. And I would say just as important is the length duration. This is where you can really control how many different families you have coming and going per year. So some of my communities have said, short-term rentals or a bed and breakfast is not more than 31 days, and the max is 90 days per year. So you can limit that way as well.
And some communities have a minimum duration for the short-term rental. And we see this most often in places like Las Vegas or New Orleans, where a lot of people would want to come and just rent the place for several hours or whatever to have a party. And they don't want that. So they've said, we're going to require you to rent it for at least 24 hours, for example. And Christy already talked about the fact that a lot of our communities want a local contact person. And that's not only if there's a party, but what if somebody gets hurt? Or what if there's a fire or other incident at the property? We really want to know, or local governments want to know, who can we contact?
And I would say that's not, in some of my communities, they don't want to limit it, be so specific to say that person, needs to be in the community. So I've had some of my communities say the contact person has to be X miles away from the community.
Yeah, but it's usually something so that that person can get to the short-term rental within some reasonable amount of time in case there is a problem. Hey, I'm getting lots of notes from my former students. Shout out to all of those. And also a good question from somebody in West Virginia. There is a big difference in West Virginia between municipalities regulating short-term rentals and counties regulating short-term rentals. The West Virginia statute limits the ability of municipalities to limit short-term rentals. Counties have a lot more tools at their disposal. I will say, however, that a lot of the tools are zoning, and a lot of communities, a lot of counties in West Virginia don't have zoning. But there are some things that you can do, like the nuisance ordinance, that would not involve zoning. And you're pretty much, in West Virginia, counties are pretty open to pursue whatever strategy that they want to pursue. A lot of communities have required permits or licenses. I will mention a Ninth Circuit Court of Appeals case that has upheld that. Spacing requirements, and I ran into this in Las Vegas. Short-term rental has to be 660 feet from any other short-term rental. And that seems odd to me. Number one, how did they pick 660 feet? Number two, it really gives incentive for people to get there first. And I want to put my short-term rental in before my neighbor does it. But they have a spacing requirement. Like Christy said, our communities generally want short-term rentals, but want to make sure that they pay taxes. And in that connection, I heard from one of our West Virginia communities, and I think she's out there today, that she had been contacted by a company who, for a fee, will search all of the Airbnb sites and find out how many short-term rentals are in your community. And if I remember right, she said that they figured that they had identified only about 25 to 50% of the short-term rentals in their community. So now there's people out there who will help you identify how many people are doing this and trying to be under the radar. Some communities require a certain type or amount of liability insurance. This does really concern me because I think both the short-term renter and the lessee, if something happens and there's not adequate insurance, everybody loses on that one. You might lose your property if you're the lessor. If you're the renter, you might end up having lots of medical bills and injuries and never get any money to pay for those. Now, some of the platforms like Airbnb, they require anyone renting through them to have liability insurance, and I think some of them even provide it as part of the fee that you pay to them to be on the platform. And I ran into in San Diego, they actually said, we're going to have a cap on the number of short-term rentals in our community. And again, that to me is kind of a difficult thing to implement, but they felt like they wanted to make sure that there weren't too many that would overwhelm the community. I've actually been overseas in Prague, for example, where the taxi driver has told me nobody who's from here can live here anymore because investors have come in and bought up all the properties. Somebody suggested that Las Vegas's 660 feet might refer to the average of houses on the neighborhood block face, and that may well be it. That's a good suggestion. So those are some of the other regulatory strategies. I wanted to make a note about homeowners associations. Homeowners associations have broad authority to regulate a lot of issues, including short-term rentals. A little scary to me because homeowners associations are not subject to a lot of the constitutional constraints that apply to local governments. But you will find in a lot of especially newer HOA documents provisions that address short-term rentals. I'm going to talk about some cases involving restrictive covenants in a few minutes. And just like ordinances, the definitions are the key. And I know some people, when you drafted your ordinance, you drafted your restrictive covenant, you had no idea how short-term rentals were going to blow up. But now you might want to revisit those definitions to make sure they fit what you want to do. So now let's talk about some recent case law. I already talked about the 2 Pennsylvania cases that said that family implies some type of stability in a nonprofit arrangement. There have been cases on the other side as well. In Connecticut and in Texas, the definition of family in these 2 cases did not prohibit short-term rentals. And this is very fact specific. It really depends on what your definition is. In Connecticut, roomers, boarders, or lodgers were excluded, but the court said it's really impossible for us to distinguish long-term versus short-term. And in the Texas case, the definition was very broad, and the court said, you know, as long as the renters themselves are a family, they're allowed, at least under that definition. There are some cases that come up on the other side. In a restrictive covenant case, the restrictive covenant limited property to residential use. And so this is not family, it's residential. And the court said that residential use implies something more than transitory. And you have to have some evidence that they're establishing some type of permanent residence. And therefore, short-term rentals are not residential use. In Massachusetts, the court, and I believe they cited the Pennsylvania cases here because they adopted their reasoning for sure. They said single-family residential zoning and short-term rentals just don't fit together. And to say that short-term rentals are allowed in single-family residential zoning is fundamentally flawed. And short-term rentals are inconsistent with the zoning purpose of single-family zoning districts, which are to preserve the residential character of the neighborhood. So again, definitions are the key. In a restrictive covenant case, and I think in these restrictive covenants, they actually allowed bed and breakfast. So I think that had a big influence on the decision. But short-term rentals did not violate the restrictive covenant that limited those properties to residential use. And the court said just because the owner gets rental income does not transform the use from residential to commercial. Some more residential use, residential character cases. And this time, actually, they're talking about dwelling. The first case is from New Hampshire. And the definition of dwelling included the phrase permanent provisions for living, sleeping, cooking, and sanitation. And the definition also said that hotels, motels, inns, and boarding house, they're prohibited. So the New Hampshire Supreme Court said that under that definition, short-term rentals are not a dwelling. And next we have a case from Virginia. And I know there are a lot of Virginia people out there today. Kind of an interesting case out of Fairfax County, where they had a definition of dwelling as used for residential occupancy, and they specifically did not include hotel, rooming house, or transient occupancy in their definition. And the court said short-term rentals are not allowed in a dwelling, a single-family dwelling. The Virginia Supreme Court in that case also found that the transient occupancy tax could be imposed even on a residence defined as a dwelling. Some more covenants, and this to me, these two cases, and I'm speculating, but I think the courts are really looking at all of the circumstances. And these two cases involved houses that were in resort areas, tourist areas. And I think the court took that into account. The first one was a fishing lodge. And the covenant said that the fishing lodge is limited to residential purposes, no business or commercial uses. And the court said that does not prohibit short-term rentals. And they said, we're going to look at what the renters are using the property for. And here it was for ordinary living purposes. The other case, kind of similar. It's a 48-acre parcel, and it was in a touristy type area. And they said the ordinance doesn't prohibit hotels, motels, rooming houses, or tourist houses in this preservation zoning district. Therefore, residence does include short-term rentals. So in addition to the language of the ordinance, I think the context of the community is really important as well. More cases, I have tons of them, but seems to be a real cottage industry here, no pun intended. But where the ordinance limited home occupations to those incident to the principal use of the building as a dwelling, and family was limited to nonprofit arrangements, the landowner was operating a prohibited business when engaging in short-term rentals. And this was a criminal case. Dorr was criminally convicted of violating that ordinance. I also ran into a number of cases. I had not seen this before, but a number of communities have a definition for what they call tourist houses. And I think tourist house is basically a short-term rental, from what I can gather. And in this particular instance, it was in a single-family residential neighborhood. The owner was using the property as a short-term rental. And the court said, no, this meets the definition of tourist home, which is not allowed in this residential district. And in this case, the definition of family included the term nonprofit. Just a few other cases here. We're going to get to some meaty cases now, some regulatory takings, freedom of speech, and some constitutional challenges. And this is a big case, Ninth Circuit Court of Appeals in federal court. This was where HomeAway, Airbnb, a number of platforms challenged a regulation in the city of Santa Monica that required the platform, required Airbnb to collect and remit taxes. They had to disclose to the local government any listing and booking information, and they had to update that regularly. They could not complete a booking for any properties that were not licensed by the city, and they could not collect a fee for facilitating a rental or providing services for a short-term rental that's not registered with the city. The B&B platforms filed a lawsuit saying that violated their First Amendment rights. And it singled out individuals involved in expressive activity in violation of the First Amendment. The Ninth Circuit said they rejected these claims and said it doesn't target conduct with significant expressive element, that just a listing for a booking does not have a significant expressive element. And it doesn't single out those engaged in expressive activity like advertising. I suspected that this case would be appealed to the United States Supreme Court, but it was not. So I'm not sure if that means that these booking platforms have accepted that they're going to have to play along with local governments or not. But for now, the highest court that has ruled on it says that local governments can do things like this, and that's a huge benefit to local governments. Zatari, I already mentioned this case, and this case, I think, is how not to regulate short-term rentals, with apologies to those of you from Austin, Texas. They said, first of all, the fact that they immediately suspended short-term rentals in buildings that are not owner-occupied, that was okay. That was not unconstitutionally retroactive. But to try to address noise and party and that type of issues, Austin had said, we're going to limit occupancy to 2 adults per bedroom. And here's where we start to get, I think, out of the bounds of the Constitution. No more than 6 adults could gather outside. So the picture I have up here, I think, is 6 adults, but if somebody else came, can't do that. No weddings, no parties, no group activities, and it was limited to 10 or 6 unrelated adults, depending on the situation. And there was a 10 p.m. curfew. So Austin really cracked down on this, and the court said that violates the First Amendment right of freedom of assembly. And this is the case where the court said, maybe you should try a nuisance ordinance instead. That would not run afoul of the First Amendment. And I don't know, Christy, do you have any examples from your communities where they've talked about doing similar things with age or number of adults or anything like that?
Yeah, I had one particular community ask me if they could limit short-term rentals to only people above the age of 30. They thought that would address partying and loud music and whatnot. And my response was, I know plenty of 30 and 40-year-olds that are just as loud and obnoxious as 20-year-olds. So I don't know how you would draw that line with age.
Yeah, when Christy came to me with that, I was very hesitant to do it. I thought it would be difficult to police and difficult to justify. Any of the lawyers or planners out there who have other suggestions, I'd be glad to hear it. But we ended up advising the community not to do that, and they ended up not doing it. This slide and the next slide actually involves one short-term rental owner in the city of New Orleans, but they're kind of two different holdings. The first, which a lot of courts have held, that homeowners don't have a vested property right and a permit for a short-term rental. So I have not seen a takings claim survive. in court, because you don't have the right to do whatever you want to do on the property. And so if they take your permit away from you, or if they regulate what you can do and require a permit, that's not a regulatory taking. But on the other hand, the city of New Orleans, the court slapped them on the wrist for having a lack of clear, non-discretionary licensing criteria. So their licensing criteria were not specific at all, very broad, very general. So the court said that that would tend to chill speech and intimidate parties into censoring their own speech. And the court said, when you require owners of short-term rentals to disclose certain things, you have to show a substantial relationship between the disclosure requirement and a sufficiently important governmental interest. And so again, it's all about doing your homework, doing your research, and making sure you can connect them. But the court said that requiring the short-term rental to display the permit, that was okay, because it allowed the guests to identify the correct property, and the public at large is informed of who to contact in case of property-related issues. So there's a case where the owner had to post that they had a permit, and here's who you contact if there's an issue. And the court said that's fine. This is an interesting case. This is a really interesting case out of Jersey City. And the mayor of Jersey City had been elected with a lot of support from some short-term rental platforms. So when he was elected, he adopted a very lenient regulation. And a lot of people came in and invested in properties for short-term rentals in New Jersey. Then, after he passed this lenient ordinance and people came in and bought properties, he went to the short-term rental platforms and said, give some money to my re-election campaign. And the short-term rental platforms didn't donate to his campaign. So the mayor passed a very restrictive ordinance that barred short-term rentals and non-owner occupied dwellings to less than 60 nights per year or less, and prohibited sublessees. And the owners of the properties brought a taking claim, and again, the court said you don't have a property interest to engage in short-term rentals, no taking. Here are a couple more takings cases, and all of them New York, United States District Court for the Northern District of Georgia, and the United States District Court for the District of Massachusetts. They all said that certain limitations, like it has to be owner occupied, or you can't rent it for periods of less than a week, or you can't engage in short-term rentals at all. None of those restrictions are regulatory takings. So I don't think local governments have to worry about takings claims with respect to short-term rentals. And we have flown through a lot of cases and a lot of possible ways to regulate short-term rentals. And Christy and I both look forward to hearing some questions and discussion at this point. And I don't know if Taylor's going to come up and join us.
Hi, yeah. So yeah, let's go ahead and move on to our questions. Just a reminder, be sure to add your questions in the Q&A box below. All right, so let's see what we've got here. We've got our first question from Floyd. What type of STR regulations are available for municipal home rule cities?
Well, Ken, you know that this is for educational purposes only and not for, this is not legal advice. But in my opinion, and I'm going to really qualify this because this is not legal advice. Just think of this as the random musings of a crazy academic, and Christy will confirm that I'm a little crazy. But in my opinion, I think home rule municipalities in West Virginia can define family in a way that excludes short-term rentals. I think obviously they can incorporate provisions into a very general nuisance ordinance that doesn't target short-term rentals. It can be owner-occupied, it can be long-term rentals. But if you engage in certain parking, noise, littering type activity, that's a nuisance. I think that's allowed. And I think the different definitions of bed and breakfast are allowed as well. I think I would have to look at the statute again, but I'm pretty sure it reserves the right to collect taxes from them. And I think as long as you are consistent with land use planning principles, I think most of what we talked about today is allowed in municipalities. I'll give another caveat. As you know, the West Virginia Supreme Court has not ruled on any of this. And if you can give me a prediction of how the West Virginia Supreme Court will rule, I would really appreciate it.
All right, looks like we had a comment or a question earlier from Robin. Perhaps 660 feet relates to Las Vegas's average of houses on neighborhood block face.
Yeah, and I had commented before that may be it. That could be the possibility. I see that we have another comment. And the question is that, you know, a lot of this relies on your definitions and the language of your ordinance or the language of the restrictive covenants. And that's certainly true. And they said, the question is this going to remain local? And gosh, that's a good question too. What happened in West Virginia is some short-term rental owners, investors got into the ear of the state legislature and they passed some legislation preempting local governments, or I'm sorry, municipalities in some ways. One other thing that I look at a lot is home rule and Dillon's rule. And the trend across the country seems to be state legislatures preempting local action. I would not be surprised to see a lot of state preemption of Airbnb regulation. That would be unfortunate in my opinion because the effects are local. And I think these really impact local governments in a profound way. And I think local governments should be able to deal with that.
It looks like we had a comment up here from Mary. She said temporary boarding houses, temporary boarding rooms were very common and many were with respectful conditions in the US. Now the single family cul-de-sacs with HOAs breeds endless complaints about just about anything. Zoning does not regulate HOAs. And then she said below that, this topic is current and growing, definitions and different codes, and of course, so many different jurisdictions. Do you not see this as remaining very local in regulations?
Christy, do you have any comments on the fact, I mean, you had the slide about Karen. Do you have any comments on the fact that now we have these cul-de-sacs with HOAs and And that's one reason we're seeing a lot of complaints.
Yeah, and I do think, at least in West Virginia, most of the complaints I have heard have been very valid in nature. However, prior to working with the land use clinic, working in local government, there are people that will complain about just about everything. But at least with short-term rentals, it seems that most people are just concerned about noise, parking, partying, and just the residential character of the neighborhood.
All right. I have another question from Tava. What jurisdictions in Virginia have good regulations for short-term rentals that we can refer to when drafting an ordinance?
Yeah, and I honestly don't know. We had Channing responded and said that Virginia Beach has some decent ordinances. There are probably, I know there are a lot of Virginia planners on this session, or at least they registered. And I would imagine that they have some good ideas about ordinances out there. But I don't know for sure. My sense is that it doesn't matter whether you're in Virginia or West Virginia or wherever you are in the country. Local governments and HOAs are playing catch up on this. And I think a lot of communities have their old definition of family that they had 50 years ago and they haven't changed it. And so I think most communities are going to have to look at their ordinance and try to update it to address some concerns that are happening now.
All right, we've got another question. This one is from Mike. Are you aware of any states that have broadly restricted local authority to regulate STR? The Michigan State Legislature is entertaining legislation that would prohibit local regulatory oversight of STR, allowing them as property right with a cap of no more than 30% STR in a community. Many LUGs in Michigan are very concerned.
Yeah, and when I did a little research for this webinar, I came across the Michigan bill. So the only ones that I'm aware of are Michigan and West Virginia. But if any of you, and Michigan's has not passed yet, West Virginia's has. If any of you all are familiar with any limits on local government ability to regulate short-term rentals, I would love to hear about it.
Right. Our next question from Molly. In using a nuisance ordinance for STRs, have communities found it an effective tool, and are there suggestions for how a community should approach enforcement?
I think that from what I've seen, nuisance has been pretty effective in regulating some of the effects of STRs. And I think the nuisance ordinance has the other advantage of, like I said, a lot of places in West Virginia will not pass zoning, but they'll pass a nuisance ordinance. And how you enforce that, you're going to have some type of mechanism where you tie it to police complaints or citizen complaints. And if it's a citizen complaint, the planner is going to have to go out and check on it. And if you get a certain number of complaints, that's declared a nuisance. And I know in West Virginia, a lot of this is done. I mentioned the drug house ordinance. A lot of this is done is like, okay, we're gonna bring this action against you for nuisance unless you clean up your act. And a lot of times the owner of the residence or short-term rental will take care of it. If they don't, you're gonna have to file a nuisance action in court. I think when you can also put penalties. If you declare it a nuisance and they don't resolve the nuisance, you can impose civil penalties on that person. And if it gets too bad, you can have criminal penalties as well.
All right. Our next question from Peter. Our county has many property covenants in our residential developments. Naturally, the county cannot be involved in covenant enforcement. Are there examples of communities that have permitted limited use of STR where there are also residential covenants?
I am not aware of any, and that, I think that's going to be a growing issue where maybe the HOAs might have a different view of short-term rentals than the local government. And so can see a lot of more clashes there, but that's a great question. And I don't have the answer for that.
Right, another one from Robin. Will you please talk about different municipal approaches to enforcing STR regulation? Are they largely complaint-based or active regulatory enforcement?
From my experience, they are mainly complaint-based, just like other type of land use regulations.
Great. Next from Adrian, how would you describe the difference between a beach rental for the week and a STR in a city?
That's a good one. You want to answer that, Christy?
You know, when we started researching short-term rentals and I was looking for definitions, I found a lot in beach communities and they just did not fit with what we wanted to do and, you know, small towns and cities. I think in a lot of beach communities, you know, beach rentals are the norm. It's not something that is out of character. And so I feel like those types of regulations are really different than short-term rental.
Yeah, I think that goes back to some of the cases that I talked about where courts, if you're at a beach or a resort area or something where there are a lot of tourists, I think the courts are going to be more lenient and say, that's kind of part of your community. Whereas if you're in a small town in West Virginia, they're not used to having a lot of short-term rentals or things like that.
Looks like we have a comment from Andrew. Virginia Code 15.2-983 allows localities to create a registry for short-term rentals. Failure to register or repeated violations of local ordinances can be used to prohibit use of the property as a short-term rental. And then it looks like we have another question over here, or a comment. In Virginia Beach, which is a large city and a beach town, we are having a hard time differentiating between beach rentals and STRs.
I would personally love to hear from people about some of those issues. I mean, that makes a lot of sense that Virginia Beach is struggling to balance the fact that they are a beach community, but there are a lot of people who live there year round as well. So some really interesting issues.
Great, we still have time for more questions. Please submit your questions, and if you want to raise your hand, please use the raise hand icon if you would like a question answered live. Jesse or Christy, do you guys have any more comments?
Anything, Christy? Hey, I just want to thank everybody for being here today. And I think we're going to hear a lot more about short-term rentals. And I'm looking forward to learning a lot from you all about how we can deal with them in our communities to have a win-win situation and to balance the advantages and some of the disadvantages. So thanks for coming.
Right, any remaining questions will be forwarded to our presenters to follow up with you. As mentioned earlier, this webinar is being recorded and will be posted on our APA, or actually on our the Mid-Atlantic Collaboration YouTube page. All of our registrants will receive a follow-up email with a recap of this presentation, as well as a link to. Thank you for joining us today.